Good morning, good afternoon, and good evening. Welcome to Seminar E of the Monique and Roland Vale People's Academy of International Law. My name is Marjorie Cohn, and I am the Dean of the People's Academy and a member of the Bureau of the International Association of Democratic Lawyers. I would like to remind people that at the bottom of your screen, there is an interpretation button. We have interpretation in English, French, and Spanish. And if you click on that button and then choose your language, then you will hear the interpretation. Our topic for today's seminar is how international law protects judicial independence and impartiality and what remains to be done in the 21st century. Today, we see nearly daily examples of attacks on the independence of the judiciary. In the United States, Donald Trump ignores and disobeys court orders, and special interests influence judges. On the international plane, Hungary is the latest example of a state party to the Rome Statute that is defying the International Criminal Court's order to provisionally arrest Israeli Prime Minister Benjamin Netanyahu, who is facing an ICC arrest warrant for war crimes and crimes against humanity. The United Nations adopted fair trial standards in the 1948 Universal Declaration of Human Rights. An independent, impartial, and competent judiciary is essential to the rule of law and the foundation upon which adequate enforcement of all rights, including non-derogable rights, depends. This seminar will review the meaning and purpose of judicial independence. It will discuss international law protections and jurisprudence and analyze their adequacy. The increasing use of national security, emergencies, and other arbitrarily declared crises to suspend, extinguish, or punish judicial independence demonstrates the need for additional international law provisions. Our faculty members for this seminar include Neri Colmenares, Salahuddin Ahmed, and Nathalie Segovia. Each of them will speak for 30 minutes. Then they will comment on each other's presentations, followed by Q&A with the registrants. Please put your questions in the Q&A box at the bottom of your screen for our discussion following the program. In the next few days, we will post the faculty presentations in English, French, and Spanish on our website, peoplesacademy.net. So I am going to briefly introduce our faculty, and then they will begin their presentations. First, we have Neri Javier Colmenares, a human rights lawyer who combines legal action with policy advocacy for the promotion, protection, and defense of human rights in the Philippines through litigation, legislation, and academic work, both as a lawyer and a legislator. He was the senior deputy minority leader of the 16th Congress during 3 terms as a member of the Philippines House of Representatives. Neri received a degree in economics at the San Beda University and a law degree at the University of the Philippines. He was an associate of the Asian Law Center of the University of Melbourne and a visiting fellow at the Australian National University. He also served as senior associate of the Center for Indonesian Law, Islam, and Society of the Melbourne Law School. Neri was a national officer of the Integrated Bar of the Philippines and acted as its advisor on legislation and advocacy and national advisor on human rights. He is currently a member of the Council of the International Bar Association, Human Rights Institute, and he was awarded the 2020 IBA Award for Outstanding Contribution by a legal practitioner to human rights. Neri is currently a bureau member of the International Association of Democratic Lawyers and Vice President of the Confederation of Lawyers in the Asia Pacific. He is Chair Emeritus of the National Union of People's Lawyers and current chairperson of Bayan Muna Party List. And he is a member of the Scientific Committee of the People's Academy of International Law. Neri will discuss attacks on the independence of the judiciary in the Philippines. Salahuddin Ahmed was called to the bar at Lincoln's Inn in the UK, and he is a litigator specializing in constitutional and commercial law in Pakistan. He has served as president of the Karachi Bar Association and the Sindh High Court Bar Association. Among the notable cases he has handled before the Supreme Court of Pakistan are constitutional challenges to laws allowing trials of civilians by military tribunals, curtailing free speech on social media, and defending the right to secret ballot. He was also part of the legal team that successfully defended a former Chief Justice of Pakistan, Justice Qazi Faiz Issa, in a reference filed by the Pakistani government to remove him from office. Salahuddin is presently appearing on behalf of 5 judges of the Islamabad High Court in a petition challenging the government's attempt to sideline them through transfers following their complaints against interference by intelligence agencies in judicial functions. Salahuddin will address attacks on the independence of the judiciary in Pakistan. Natalie Segovia is a Quechua international human rights attorney whose work as executive director of the Water Protective Legal Collective, an indigenous-led legal organization born out of the No DAPL resistance at Standing Rock, focuses on the protection of water protectors, frontline defenders, the earth, and indigenous peoples affected by forced displacement, desecration of sacred lands, and human rights violations due to extractive industry. Natalie's international work includes human rights field work, documenting violations in rural, unseen areas in countries including Colombia, Peru, Bolivia, and Brazil at the United Nations. A frequent lecturer in law, in 2022, she was named Gilvaber Distinguished Public Interest Lecturer at Northeastern University School of Law, and she taught a course on In Defense of the Sacred, Human Rights, Earth Justice, and the Law. Natalie holds a law degree from Arizona State University and dual degrees in political science and Latin American studies from Columbia University. She currently serves on the scientific committee of the People's Academy of International Law and on the board of directors for Indigenous Peoples' Rights International. Natalie will discuss attacks on the independence of the judiciary in the United States, including in the recent Greenpeace case. So we will begin with Neri. Thank you.
Thank you. Thank you, Marjorie. Yes, I have some slides. I have 30 minutes, so I'm going to skip a few slides because 30 minutes with the slides. So maybe I think it will be posted in the website, so maybe you can review some of the slides that I will skip, no? Secondly, I did a survey of the various appointment processes in Asia based on researches by fellow scholars and colleagues from Asia who may want to update the research. I would be very happy to update the research on these appointment processes in Asia. So can we share the slide, Erin? Yes. So the outline, next slide, please. The outline of my discussion here would focus on three points only. First, the constitutional and statutory protection of judicial independence, no, under international law, and of course, Philippine Constitution. I just segregated four elements of judicial. The previous slide, please. Uh, I just mentioned four elements of judicial. The slide before that. Um, Yeah, okay. So I just mentioned four elements of judicial independence in constitutional and statutory terms. And then the last point would probably be on attacks on lawyers and, of course, the action that is recommended in this case. So under international law, I think there are a lot of provisions that signify protection and recognition of judicial independence. No, the UN Basic Principles on the Independence of the Judiciary said that it shall be guaranteed by the state and enshrined in the Constitution or the law of the country. So it is a duty and an obligation of government to make sure that the judicial system in place must be impartial and independent. In the case of Miguel Gonzalez del Rio versus Peru, the Human Rights Committee declared that an independent and impartial tribunal is an absolute right that may suffer no exception. So, in a sense, it's a non-derogable right in a sense because if you have a justice system, you have to make sure that it is independent and impartial. The principle of separation of powers is enshrined in the report of the Special Rapporteur on Independence of Judges and Lawyers, and stating that the principle of separation of powers is the bedrock upon which the requirement of judicial independence and impartiality are founded. My comment on this is that, yes, well, separation of power is recognized by many lawyers as part of a constitutional provision on the issue of separation of powers. Despite that, however, any constitutional protection on the independence of the judiciary, there are ways that state circumvents the constitutional and statutory protection and even international law prohibition of intervention or interference in the judiciary by some other means. We will go into that later. Next slide, please. So, under the Philippine Constitution, the elements of judicial independence is one, of course, separation of power, as mentioned above. The Constitution precisely states that the judicial power shall be vested in one Supreme Court. It cannot be exercised by any other power, executive or legislative, but just the judiciary. And the Supreme Court has an expanded jurisdiction from its traditional power to resolve controversies because it is now given under our constitution the power to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on any branch of the government. So that's on the issue of separation of powers. Next slide, please. Well, the security of tenure is also enshrined in our Constitution, as well as eligibility requirements. The members of the Supreme Court and judges of the lower court shall hold office during good behavior until they reach the age of 70 years old. So essentially, there is no way that an executive can, or even a legislature for that matter, can shorten the tenure of the judiciary by mere statute or edict. Therefore, in that sense, the Constitution has provided that security of tenure. Third, fiscal autonomy. Well, the Constitution states that the judiciary shall enjoy fiscal autonomy. Appropriation for the judiciary may not be reduced by the legislature from the previous year's budget. And after the approval of the appropriation for the judiciary, it shall be automatically released. So meaning to say, there is no way that the executive can threaten the fiscal independence of the judiciary, which is another facet of the factors assuring judicial independence. Next slide, please. Well, the very important aspect of judicial independence, of course, is an independent appointment process. In the Philippines, the Supreme Court and judges of the lower courts are, of course, appointed by our president, but it comes from our list of at least three nominees prepared by the Judicial Bar Council, composed of seven independent people from the integrated bar, from the academe, one from the legislature, and one from the Department of Justice, and so on. So in that sense, there is a checks and balance in the appointment process, and people say, well, that provision assures an independent appointment process. However, despite these constitutional provisions assuring independence of the judiciary, it must be recognized that in the Philippines, the judiciary is the weakest of the three branches of our government. The judiciary enjoys just less than 1% of the total budget of the government. And courts are not constitutionally built to do political lobbying, meaning to say it cannot go to Congress and ask for more budget in the sense that it has to recognize it is a co-equal branch, and the justices do not normally go to Congress for to lobby for budget. Um, and of course, lastly, it is the weakest because of the nature of our courts. That is, it has to decide in favor of one party over the other. So thus, the courts here, the Philippine Supreme Court, have no political base. It cannot develop a political base like the executive or the legislative in that sense. So it is the weakest branch of government, although under our constitution, it has the power to declare any act of government or any branch of government uh, grave abuse of discretion on invalidate any act of both the legislature and the executive. Next slide, please. However, despite such questions on that such assurance of independence, there have been these debates on the issue of appointments. The fact that the president appoints the judiciary, many believe here also, actually compromises the independence. So people here in the Philippines actually said that it is good that the legibility requirement of the judiciary is enshrined in the constitution rather than law. And Philippines, similar to Malaysia and Brunei, and to some extent Singapore, Indonesia, and Thailand, enshrined these legibility requirements in their constitution. And in Japan and Taiwan, it is merely by law. And people say that will grant the legislature the power to interfere because they can amend eligibility requirements or jurisdiction depending on the law. So that is still a debate in some areas in Asia. But the second is the belief that citizenship is an assurance of independence, that judges and justices cannot be foreigners because they are beholden to the interest of foreigners. And that's a very strict rule in many Asian countries, the citizenship requirement of judges and justices, as if the citizenship formality is an assurance of independence in favor of the Filipinos as against the wishes of big countries like the United States. Well, there had been issues, of course, in the Philippines where many assert that the judiciary has ruled more in favor of foreigners than like the United States when the U.S. bases were here, precisely to show that citizenship is not equated with independence from foreign dictates. But in our case, we have a very strict citizenship requirement in the Philippines. You have to be natural born, not just a citizen, similar to Cambodia and Myanmar. Among the Asian countries that have not no strict independent citizenship requirement is Hong Kong and Brunei. Now, um, does this assure independence? As I mentioned a while ago, not really. It doesn't automatically translate to an independent judiciary merely because on issues of citizenship. Well, the issues of appointing power, as I mentioned a while ago, is an issue in the Philippines too. Normally in Asia, it's the president or the king who appoints members of the judiciary, except in Laos and China, where it's the legislature who appoints the judiciary. Next slide, please. So there is this concept of a self-perpetuating judiciary where it is the judiciary itself which appoints members of the judiciary in the lower courts. Does this assure that the executive and the legislative cannot interfere? Later on, I would forward a thesis that not necessarily also, no? So judicial appointments in South Korea and Taiwan for the lower courts, there is that self sort of concept of self-perpetuating, but in general, it is usually the king or the president who appoints the members of the judiciary. Representative appointment is an idea tackled in the Philippines also, that one-third of the Constitutional Court or the Supreme Court come from the executive, legislative, and judiciary. So it's a division of one-third, 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 similar to that in Mongolia, South Korea, and Indonesia. Vietnam as a unique system wherein it's the judiciary who nominates to the parliament, and the parliament recommends to the executive, and the executive appoints. So it's a sort of collaboration of the three branches of government. In any case, all this debate in the Philippines about the appointment, the independence of the appointment process, uh, in a way is subverted by the fact that there are, despite the constitutional and statutory provisions protecting the independence of the judiciary, the executive managed, the state in fact managed to compromise the independence of the judiciary some other way. And next slide please, I'd like to point some. One, the judicial attacks on judges and justices. That's the way. Even if the Constitution is clear cut as the separation of power and security of tenure and so on, you just attack the judges and the justices, and immediately the entire judicial system is compromised. And that is seen in the removal of the Chief Justice of the Philippines by the President Rodrigo Duterte. President Duterte issued a drug list of thousands and thousands of drugs addicts and suspects and so on. Within the list, are seven judges of the lower courts. Because thousands of suspects in the list began dying, the Chief Justice wrote a letter to the President saying, "We're very concerned. Could you give us the evidence and grant us the, because we have under the Constitution, the Supreme Court as the supervisory power over all courts, we will investigate them. And we hope the executive will not investigate the judges." President Duterte declares the Chief Justice his enemy for such really a very, should we say, a very normal response from the Chief Justice. And she was, well, there was an impeachment case against her because under the Philippine Constitution, the Chief Justice and justices of the court can only be removed through an impeachment trial. But in the end, the Chief Justice was removed with a novel case of quo warranto. Many are still questioning whether you can remove an official like the Chief Justice outside an impeachment process, but in the end, the Chief Justice was removed through a quo warranto case in court. And the moment that the Chief Justice was successfully removed by the President, it already causes chilling effect on all just judges and justices. Because if the President can remove the Chief Justice, how much more can lower courts, right? So that, in a sense, is already the use of legal processes or abuse of legal processes to compromise the independence of the judiciary. Next slide, please. And of course, there are also attacks on judges for their decision. Judge Monique Lagdameo was red tagged after she ordered the release of two illegally arrested activists. What is red tagging? Red tagging is the public condemnation of a person of being a member of the Communist Party or the New People's Army. Now, the moment that you are red tagged, then you are isolated. It's not merely an issue of libel or slander, because in the Philippines, people who are red tagged more often than not end up dead, because those in the list of being red tagged or supposedly suspected of being communist are killed through extrajudicial killings, and about 1,000 under Duterte were killed. Activists who were red tagged before they were killed. The second is Judge Marlo Malagara, who was red tagged also after she dismissed a petition of the government of President Duterte to proscribe the CPP-NPA, the Communist Party, as a terrorist organization. In her decision, she said the CPP-NPA was not organized for the purpose of engaging in terrorism, but is a revolution through armed struggle, not for violence sake, but in the pursuit of the higher ideals contained in the CPP's constitution. Guerrilla warfare, she said, is not synonymous with terrorism. After she made that decision, huge, massive attacks against her for being a communist cuddler or sympathizer, a member of the New People's Army, that the Supreme Court had to intervene and warn anyone who continues to red tag members of the judiciary with extreme powers of the court. So those are examples. Next slide, please. Other than red tagging, judges are also killed. 28 judges have been killed in the Philippines since 2001. 15 in the 9 years of President Gloria Arroyo. Five judges were killed in the term of President Aquino from 2010 to 2016. Eight judges were killed under President Duterte's 6-year term from 2016 to 2022. Under the current administration of President Marcos, we have not recorded a judge who was killed, but 9 judges have been subjected to attacks, red tagging, threats, and other attacks. So this is the state of the field in the Philippines, where judges are threatened because of their decision, and that practically compromises the judiciary's independence and impartiality. Next slide, please. There is, of course, another record Marjorie mentioned a while ago about the International Criminal Court. Our former president, Rodrigo Duterte, committed what is called the fifth crime under the ICC, which is an attack on the administration of justice of the ICC. A case was filed against President Duterte. Some victims, families of victims of extrajudicial killings or EJK, went to us, human rights lawyers of the NUPL, way back in 2018, to ask that we file cases against President Duterte for the killing of their sons, their daughters, their parents. But we said that under the Philippine jurisprudence, the president is immune from suit. So it will be dismissed by the courts, of course, other than the fact that the President Duterte controls the investigators, the prosecution, and so on. So that was the reason why we filed the case in the ICC, as the families of the victims wanted justice for their slain loved ones. However, President Duterte, who is intolerant of dissent, not only attacked the victims, not only attacked us lawyers, but even the ICC when he threatens to arrest the prosecutor if she investigates in the Philippines. He also threatened to slap the ICC prosecutor. Our president has a very, should we say, intolerance of dissent. He said, and that short lady there, the black, announcing investigation, if I see you, I will slap you. I mean, not only did he threaten to slap her, but he mentioned words like the black and the short. So we are really very, very ashamed of our president during that time. And then he lashed out at the court and said, "You're all whites and you're stupid white people," and so on. Did that threaten the ICC? I think the prosecutor would have wanted to visit the Philippines and investigate for herself. That was Bensuda that time. But of course, because of the threat, she did not go to the Philippines. So in that sense, therefore, then, despite the constitutional and statutory assurance of judicial independence in the Philippines, the president did never, of course, violated the provision against, for example, fiscal autonomy, or separation of power. He will always, of course, all presidents follow the decision of the court. But the way to threaten judicial independence is to sidestep these statutory and constitutional processes through threats, through red tagging, through other use of force and duress on the judiciary. So basically, next slide, please. That is the problem here in the Philippines. So statutory reforms, for example, ensuring judicial independence, of course, if we abide by Article 14 of the ICCPR and the UN Basic Principles, then for us, these provisions are already enshrined, and it's more than sufficient, actually, if only the Philippine state will follow these principles. That is, there's even no need, in a sense, for major overhaul, as far as Philippines is concerned, of course, of this constitution statutory provision. Maybe there should be focused more, rather than the assurance of institutional independence of the judiciary, such as security of tenure, the appointment process, and so on. Also focus on this other kind of action of the state, which is to attack the judiciary, rather than attack the independence of the judiciary by violating things like security of tenure and so on. Because it's more effective, I would like to I believe, is more effective in compromising the independence of judiciary rather than employing means to violate constitutional provisions. Now, focus on state practice. We hope that the international community will focus on state practice of threatening judges to stifle dissent. Red tagging, of course, is nothing else than just an effort or an attempt to stifle dissent. Because the moment you're called a communist, the moment you're called a New People's Army member, then you have to shut up. Otherwise, you can be killed. So that is the purpose of red tagging, and it's beyond a mere case of libel or slander on the dignity of a person, so to speak, but rather it is a threat to life, liberty, and security of the red tag victims. Lastly, of course, one of the things that maybe is important is the increase of solidarity and political support. Maybe if we can recommend international monitoring and documentation of attacks, I don't know if IADL can do that, but at least monitor the attacks against judges and lawyers, compile all these reports so that we can there could be some response on various countries or at least various law groups. Encourage judicial action against threats. For example, what I mean there is the Supreme Court issued a very strong statement after the red tagging of judges in the Philippines, and actions on the part of other countries, for example, encouraging the Supreme Court and finding the court's action courageous and so on, would help a lot. And I was talking to Salahuddin last meeting, when their chief justice was being removed. We had rallies in front of the Pakistani embassy together with the integrated bar. The integrated bar do not usually join rallies, but in that issue, the integrated bar, together with the National Union of People's Lawyers, we held rallies and delivered our letter to the Pakistani ambassador. So, protesting against attacks on judges and lawyers would be an important aspect of hoping or at least strengthening the independence or of the judiciary. Conducting fact-finding missions, of course, is a very important aspect, because we notice every time there's an international fact-finding mission in the Philippines, the attacks lessen. So it's not merely documenting what is happening in the country in terms of attacks against lawyers and judges. And during the time of President Duterte, 64 lawyers were killed in the 6 years of President Duterte. But because of the fact-finding missions and so on, there has been some effort on the part of the state to lessen the attacks, especially during the time when the fact-finding mission is present and when the report of the fact-finding mission is issued. So in the end, while institutional and statutory provisions in the Constitution and international law would help a lot, of course, in advancing the independence of the judiciary, stronger solidarity relations with threatened judges and lawyers would help also in making sure that not only are the constitutional provisions recognized, but any attack, any violation of such independence will be held to account, not just by the Filipino people, but by the international community. Thank you very much for inviting me to this forum. Thank you.
Thank you so much, Neri, for explaining to us how judges are attacked by the government through killings, red taggings, and inclusion on these so-called drug lists, which compromise the separation of powers and the importance of solidarity. And I also want to thank you for participating in this seminar, because it's midnight in the Philippines and you are in the middle of a major congressional campaign. So we really appreciate the fact that you could be here. Thank you so much.
Thank you.
And next, Salahuddin, you're up.
Thank you, Marjorie. Um, it's an honor to be invited to speak at this forum on the state of judicial independence in an international context. I intend to break this paper up into three parts. Firstly, I'll start with describing the international instruments and the normative and prescriptive standards prescribed in relation to the independence of judiciary. Next, I'll move on to the seemingly global regression um, from these standards, as witnessed in both economically advanced and less economically advanced countries. And of course, since I practice law in Pakistan, I will in particular trace the rise and fall of judicial independence in our country, and especially after the recent 26th constitutional amendment. And thirdly, finally, I'll suggest some steps that can be taken by the global community of lawyers and academics to address this regression, despite living in a world that seems to be moving away from a rules based order towards a might is right kind of order, both on an international scale and in many countries domestically. Now, as far as the first part is concerned, the international standards. Now, the independence of judiciary is almost universally recognized as a global normative standard. A good place to begin is probably the Universal Declaration of Human Rights, which Marjorie referred to, which was adopted by the United Nations in 1948. Article 10 says everyone is entitled to full equality, to a full, fair, and public hearing by an independent and impartial tribunal in the determination of his rights and obligations and of any criminal charge against him. Now, in 1976, the International Covenant on Civil and Political Rights came into force, which has now been acceded to by no less than 174 countries. So that's pretty much, it's close to nearly all the countries. And Article 14.1 of the ICCPR again states that, in the determination of any criminal charge against him or of his rights and obligations in a suit at law, everyone shall be entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law. Similarly, Article 6 of the European Convention on Human Rights, it's almost in exactly the same terms. It's been adopted by not just the members of the EU, but nearly all the countries on the European continent, from Turkey all the way up to Iceland. Then Article 8 of the American Convention on Human Rights, which has been ratified by nearly all of the countries in Central and South America. That is in the same terms. Article 26 of the African Charter on Human and People's Rights, which has been adopted by all African nations. That also binds each state to guarantee the independence of the courts. So, as much as it can be, the right of access to an independent judiciary is globally recognized as a basic human right. And the overwhelming majority of countries have undertaken to protect this right as an international treaty obligation. Now we come to the international prescriptive standards for an independent judiciary. So it's all very well to recognize that the judiciary of every country should be independent and free from external influence, especially that of the government. But how is that goal to be realized? What are the basic safeguards and measures that all states should undertake so that their judiciaries can truly be considered independent? Now, international organizations and bodies have done a lot of work on that too. Again, let's start with the United Nations. So in 1985, the United Nations adopted the basic principles on the independence of judiciary, aiming to fill the gap between the vision enunciated in the Declaration of Human Rights and the ICCPR and the actual situation on the ground. So the basic principles asked member states to ensure, amongst other things, number one, that the independence of their respective judiciaries was guaranteed under the Constitution or their law. Number two, that the judiciaries were given exclusive jurisdiction to decide all questions of judicial nature and the authority to decide whether any question fell within its jurisdictional competence or not. Also, that ordinary courts following the ordinary process of law should not be supplanted by special tribunals that did not follow the established legal process, such as military tribunals, etc. And thirdly, that the judiciary was protected from all sorts of external pressure whilst deciding cases, whether it be through inducement, influence, pressure, or threats from any quarter or source. Fourthly, that judges should be appointed on merit, having regard to integrity and ability. And the process for selection should guard against selection for improper motives or against any sort of discrimination. Then, fifthly, that judges should have security of tenure, so they cannot be threatened with removal for unpopular or unfavorable decisions. And suspension or removal of judges should only be after fair hearing and only in case of violation of established standards of judicial conduct. Also, that their promotions within the judiciary should be on objective factors and criteria through a transparent process. Then, sixthly, that the assignment of cases within the judiciary should be a matter of internal judicial administration. So basically, so that governments can't pick and choose which judge gets to hear which case, and especially the cases that are of importance to the governments. In 1989, the United Nations member states were asked to provide reports to the UN every 5 years, mentioning their progress in ensuring the implementation of these basic principles. And the same year, the United Nations Commission on Human Rights, it also asks all the member states that whilst implementing the basic principles, they should also take into account the draft Universal Declaration on Independence of Judiciary, which is also known as the Singvi Declaration. Now, the Singvi Declaration provided, amongst other things, that not only should judges be free from external influence, i.e., from the government or the legislature, but they should also be free from internal influence whilst reaching their decision in any individual case. So, whether that pressure was vertical or horizontal pressure from other judges in the judicial hierarchy. Secondly, that in the selection of judges, the input of the judiciary and the bar lawyers was essential. And whilst the involvement of the executive and the legislature in the process was acceptable, it was only acceptable so long as scrupulous safeguards were maintained against improper reasons or motives for judicial appointments. Thirdly, that the executive should not try to usurp the jurisdiction of ordinary courts, and they should not be replaced by ad hoc courts or ad hoc tribunals. And in particular, the jurisdiction of military tribunals should be confined to military offenses only. As you know, in many countries of the world, court martials and military tribunals are used as a method to try people and convict people and punish people without giving them the safeguards of due process. And the fourthly, the Singvi Declaration provided that the administration of justice and overall functioning and process of courts should be under control of the judiciary itself. The executive should not make an attempt to usurp that control, and it should make available adequate resources for the judiciary to perform its functions. Fifthly, that judicial verdicts should be respected and enforced by the executive, and neither the executive nor the legislature should attempt to retroactively reverse a specific court decision, nor to change the composition of the court to affect its decision making. Sixthly, that postings, transfers, and assignments of judges should be done by the judiciary or through a judicial council or body and not by the executive. And that of judges should be with their consent, except where transfers are done as per a routine uniform policy. Then, seventhly, that not only the tenure of judges should be secure, but their terms and conditions of service and their remuneration should be protected by law and not altered to their disadvantage. And the removal of judges should only be on proved grounds of incapacity or misbehavior, rendering them unfit to hold office. And then finally, which is very relevant to what Neri was talking about, that the executive should ensure the security and protection of judges and their families, and they should not be sued or prosecuted in respect of their judicial conduct, except under authorization of an appropriate judicial authority. Now, similar kinds of prescriptions are there in the various declarations and charters by private international organizations such as the International Bar Association and the International Association of Judges, that has representatives from the national judiciaries of over 80 countries. Now, the Universal Charter of the Judge, approved in Taiwan in 1999 by the International Association of Judges, is particularly relevant, and it elaborates upon the principles that are set out in the Singvi Declaration. Now, coming to Europe, the Council of Europe also issued recommendations in 1994 in similar terms, and they also additionally prescribed, amongst other things, that the body taking decisions on the selection and career prospects of judges should ordinarily be independent from the government. And it should be done by members selected by the judiciary itself, with the caveat that in countries where the constitution or law allowed the executive to be involved in this process, there should be adequate safeguards to ensure that all such decisions relating to selection or promotions of judges should be based on objective criteria only and not for any improper motives. And also, secondly, that the assignment and distribution of cases within a court should be through an objective or automatic process, and there should be no external influence in this regard, because that is also one of the ways through which judicial outcomes are manipulated when a non-judicial body or a government can basically select the judges that listen to a particular case. In 1999, the Council of Europe formally adopted the European Charter on the Statute of Judges, where member states were asked to ensure that in bodies responsible for selection, career advancement, or termination of a judge, at least 50% of the body should be judges selected by their peers. Now, similarly, the Commonwealth, an association of 56 countries that were formerly British territories, they have also laid down their prescriptive standards relating to the independence of judiciary, which are broadly speaking in line with those prescribed by the UN and the Council of Europe. These are known as the Latimer House Principles, framed in 1999. Then there is the Beijing Statement of Principles on the Independence of Judiciary, which was adopted in 1997 and signed by 32 Chief Justices in the Asia-Pacific region. In Africa, the African Union has done the same through their heads of states of affirmation in 2003, adopting the principles and guidelines on the right to fair trial and legal assistance in Africa. So pretty much no matter where in the world you are, the general norms and the specific prescriptions for an independent judiciary are already there. In many cases, they're also part of the specific international treaty obligations of the individual country. Of course, in some countries, like mostly civil law jurisdictions, ratified treaty obligations automatically become part of the domestic law, whilst in other countries, mostly common law jurisdictions, they only become part of domestic law if formally adopted by their legislatures. But even in the latter case, usually the general principle of interpretation followed in most common law jurisdictions, as far as possible, the courts will, in any event, interpret domestic laws on a subject in line with the country's international treaty obligations. So, that by itself can be one effective way of empowering judicial independence by using public interest litigation in each country's own domestic court system to promote judicial independence in line with any international instruments or normative or prescriptive standards that the country in question has subscribed to. But I'll cover that more in the third part of my paper. For now, I want to move to the second part, which is the global regression in judicial independence. So, all countries have their own unique struggles with the independence of judiciary. But recently, we have seen a more global trend where the executive and legislature of many different countries have sought to establish their dominance over the judiciary. It's not a coincidence that this has come hand in hand with a global rise in national populism. And it is, of course, it's part of history that invariably nationalist, populist leaders see an independent judiciary as both a threat and a restraint on the untrammeled power they wish to exercise. Now, in the USA, I think Marjorie mentioned the Trump administration. We see, the administration and legislative leaders arguing that judges who have passed decisions against them should simply be removed or their courts reconstituted, or judicial orders are simply not followed. Even in the United Kingdom, when the Supreme Court passed certain decisions in relation to Brexit, some politicians and some sections of the media, termed them as being unelected enemies of the people. And this is, of course, a classic example of external influence and pressure being brought upon a judge in his decision making. And what many people fail to understand in this ostensibly democratic argument against unelected judges forcing their will, upon elected governments, is that it's not the job of a judge to pass decisions in accord with the popular will. In fact, quite often his or her job is the opposite, to protect weaker sections of society from undue expressions of majoritarian or populist will. That is what Bill of Rights and fundamental rights, or whatever, however they are termed in your respective country, that is what they're all about. It is about protecting minorities. Now, in the United States, we also see this increased determination by politicians on both sides to ensure that only judges sharing their political views are appointed or elected to the bench. So when you have a situation where the president or the Senate votes to select a judge primarily on the basis of his political views, and his or her professional competence or integrity becomes secondary, I think that poses very serious questions for the independence of judiciary, and it's contrary to prescribed international standards. Likewise, when judges to Supreme Courts, state Supreme Courts are elected, and you have ridiculous amounts of money being spent in their campaign, upwards of $100 million, or where one donor like Elon Musk can contribute $25 million to the Wisconsin state Supreme Court elections, that raises serious concerns about outside influences on the judiciary. Now, coming to Europe, in Poland, we saw the ironically named Law and Justice Party. It took a flurry of measures to fetter the independence of judiciary by initiating disciplinary actions against disobedient judges, changing the composition of constitutional courts, changing the quorums and procedures of the courts to make it more difficult for them to strike down legislative or executive acts, lowering retirement ages for judges, starting online media campaign against judges. Now, although the European Union and the European Commission took some measures to combat that, but those are clearly, up till now, not effective. And a similar situation, as Marjorie pointed out, is in Hungary, where the executive took all the steps it could take to subjugate the judiciary by firstly dominating the process of appointing court presidents, then controlling the process of promoting judges, and using constitutional amendments because they had a sufficient majority, using those constitutional amendments to engage in court packing and restricting the judiciary's ability to engage in judicial review. Likewise, in Israel, the Netanyahu government made changes to its basic laws to curb the judiciary's power to exercise judicial review and to enhance the government's control over judicial appointments. So we've seen similar developments in many other countries, like in South America, Africa, Asia, even countries like India, with a long-standing history of judicial independence, has seen a regression where, the Indian Supreme Court has been kowtowing to the Modi government. Now, Pakistan too is no exception to that regressive trend. The Pakistan judiciary historically was seen as, although there were formal guarantees of its independence in the constitution, but it was always seen as subservient to the executive, and especially to the Pakistani military, which has always had an oversized influence on the country's politics. But beginning from the late 80s, the Pakistani judiciary made a concerted effort to establish a greater independence from the executive. Now, in 2007, this exercise to garner greater independence eventually led to the sacking and house arrest of Chief Justice of the Supreme Court, Iftikhar Chaudhry, whose example Neri had referred to. At that time, Pakistan was under military rule led by General Pervez Musharraf. But once Iftikhar Chaudhry was sacked and put under house arrest, it sparked public protests by lawyers, bar associations. Many of us lawyers went to jail at that time. We were imprisoned during those protests. And that public protest was then joined by civil society organizations and eventually by political parties. And it attracted a great deal of international attention from bar associations, human rights organizations, academics, universities, from the United States at one end to Malaysia, Philippines on the other. There were rallies in different countries. There were events, conventions on it. And eventually, the culmination of the domestic and international pressure was that General Musharraf was ousted and democratic rule in Pakistan was restored. And then in 2008, after he left, after he was forced out, a constitutional amendment was brought in, which increased the role of the Pakistani judiciary in judicial appointments, and the government's direct interference was lessened. A judicial commission was created. In that judicial commission, judges were in the majority. The government had some nominees, and the bar had some nominees, but the majority was of judges. And after the judges would choose a particular candidate for judicial office, it would go to the parliamentary committee, but for final approval. But the parliamentary committee, it could not reject a judge for competence, etc. That was a issue that the Judicial Commission would decide. It could only reject it if there were other, problems with, integrity, etc. So the balance was firmly in favor of the judiciary. But with the resurgence of the judiciary in Pakistan, that led to resentments both within the military forces and successive elected governments in Pakistan. So media campaigns were started against judges that passed decisions that were disliked by the executive. Their phone conversations were tapped. They would be released to the public. They would be doxxed on social media. Their family members would be doxxed, and their pictures would be released on social media. Intelligence agencies got involved. They tried to have Supreme Court judges and High Court judges removed on one pretext or another. So in 2023, and that was one of the cases in which I'm still appearing, 6 judges of the Islamabad High Court, which is the capital city, they made an official complaint that intelligence agencies were continually pressuring them to decide important cases in line with their directions. They pointed out and they, surrendered secret cameras that had been discovered in their bedrooms. They pointed out that their relatives had been abducted and told to pass messages to them to behave themselves. After that, they received letters containing suspicious chemical powders. And when the Supreme Court of Pakistan asked the other 4 provincial high courts whether their judges had been subjected to similar pressure and intimidation, they all said that yes, we've also been facing similar problems. But the Supreme Court of Pakistan took notice of this and they had a couple of hearings. But then, when this covert method of pressurizing the judiciary was exposed, the executive and legislature adopted a more overt method and they passed the 26th constitutional amendment. Now, it's important to note that this was soon after the highly contested elections in Pakistan, 2023 elections, in which were widely alleged to have been rigged against the most popular political party, the PTI, led by former Prime Minister Imran Khan, who's presently in jail. Now, the results of those elections had been challenged in various courts, and that was a source of great tension for the new government. So, the new government got together with its allies and they passed the 26th constitutional amendment that allowed them to basically control the judiciary completely. Now, even during the passage of this constitutional amendment, several opposition leaders, members, senators, members of assembly, they gave interviews, they gave affidavits claiming that their relatives, either they personally or their relatives, had been abducted by intelligence agencies and ordered to vote in favor of the constitutional amendment. Despite all that coercion, the amendment was only passed with one extra vote. But as soon as it was passed, it basically spelled the death knell for the Pakistani judiciary. Now, what it did, firstly, it allowed the ruling parties to appoint the Chief Justice of Pakistan. Previously, the Chief Justice of Pakistan under the Constitution was appointed automatically. The most senior judge of the Supreme Court would invariably become the Chief Justice. But they took the power to select the Chief Justice and they bypassed the most senior judge, Justice Mansoor Ali Shah, who was seen as more independent, and they appointed someone who they considered as more pliable as Chief Justice of Pakistan. Then the 26th Amendment, it also modified the composition of the Judicial Commission. So, whereas previously judges had held the majority on the Judicial Commission, but through this amendment, they allowed the government basically to effectively control the Judicial Commission, and judges were left in the minority. And so basically, all judicial appointments and promotions now became the prerogative of the government. Most crucially, what this 26th Amendment does, and it's very recent, it's only barely 6 months old, it creates special constitutional benches within the high courts and Supreme Courts of Pakistan. Now, those constitutional benches, they have now been given exclusive jurisdiction to hear cases of constitutional importance against the government. Now, those constitutional benches are also selected by the Judicial Commission, which, as I said before, has become a proxy for the government. And the members of those constitutional benches don't have any security of tenure. So they can be removed from those benches at any time. And basically, the government now gets to handpick the judges that can hear cases against the government. And obviously, the results of that have been that in the last 6 months, pretty much every case that has been filed against the government has been dismissed. And to add a final, a parting blow, the constitutional amendment prescribes that judges will now have to go through an annual performance evaluation. And that annual performance evaluation will again be conducted by that proxy judicial commission. And any judge who gets more than two negative annual performance evaluations, automatically proceedings will be triggered to remove him. And as far as those 6 judges of the Islamabad High Court who had dared to complain about interference in judicial affairs by intelligence agencies, the government promptly sidelined them by appointing a new Chief Justice over them. And that new Chief Justice removed them from all cases, from all benches hearing any kind of case of any kind of interest to the government. So, as of today, we have no semblance even of an independent judiciary in Pakistan. And the tragedy of it is that it has been effected not by a military regime through martial law, but by a purportedly elected government through constitutional amendment. So, what is to be done? And that brings me to the final part of my paper. In the first place, I think lawyers and activists in countries facing such threats have to do whatever is possible to resist. Now, there is political resistance, of course, which is essential. But I think that they should also attempt to spark and promote judicial resistance to such measures. Judges cannot and should not just roll over when faced with such threats to judicial independence. Now, of course, when the threats to judicial independence come from legislative or even constitutional amendments and from elected executives, judges are often very wary of being accused of judicial overreach or of thrusting themselves into the political sphere. But I think that a very fine paper regarding the duty of judges in such circumstances has been authored by P.J. Castillo-Ortiz of the UK and Yaniv Roznai of Israel, which is entitled The Democratic Self-Defense of Constitutional Courts. I'd encourage all of you to read it if you have not. And they recommend that in cases where the tools of democracy are being used, which is, legislative action, constitutional amendments, are being used to destroy the very basis of democracy, to destroy the very semblance of an independent judiciary, then it is incumbent upon judges to further expand their powers of judicial review to protect constitutional systems and the trichotomy of powers. Secondly, as far as the international community is concerned, I think there needs to be greater seriousness and, just as important, greater consistency in the attitude of international bodies towards countries that breach international obligations relating to the independence of judiciary. So, for example, Marjorie mentioned, Viktor Orban's refusal to allow the ICC warrant against Netanyahu to be executed. Now, not on this issue, but on earlier violations, the EU had taken action against Hungary. But what will the EU do when Germany, which has just now invited Netanyahu, despite those warrants, to come to Germany, and despite being a signatory to the ICC convention? Now, that is something, this kind of, disparity in condemnation, depending on the country that takes such measures, that needs to be addressed. And then finally, thirdly, I think in times like these, it is essential for lawyers and academics to join their voices globally, to raise greater awareness, to create a pushback against this global regression of judicial independence. And that's why I'm delighted to have been called today, included in this lecture series by IADL and the People's Academy. And I'd just like to thank you all for your patience.
Thank you so much, Salahuddin, for tracing the development of the international law on the development, the development of the international law to protect the independence of the judiciary, as well as global regression and special interests to undermine an independent judiciary, including in Pakistan, and strategies for resistance to attacks on the independence of the judiciary. And I want to add that in 2007, 2008, when I was president of the National Lawyers Guild, we acted in solidarity with Pakistani lawyers who resisted the attacks on independent judges, and many of them faced incredible repression for doing that. So thank you again. Next, we have Nathalie. You're up.
Thank you, Marjorie, and thank you, Salahuddin and Neri. It's an honor for me to be here today, and there's so much of what's been covered. You know, it's a different, same story in a different place, right? I'm focusing mainly on the U.S., and we do have a PowerPoint that, Erin, if you could share that, that would be great. So I'm speaking today really from the perspective of lawfare, right, and threats to judicial impartiality and the rule of law. As Marjorie already went over this, next slide, Water Protector Legal Collective is an Indigenous-led nonprofit law firm and advocacy organization that began at Standing Rock in support of water protectors who are facing criminalization from their opposition to the Dakota Access Pipeline in 2016. So WPLC was formerly based out of North Dakota, and we responded to that mass criminalization of water protectors that was seen at Standing Rock. I'm going to go a little bit quickly here since I know we're short on time today and we have so much good conversation to cover. Importantly, though, there were nearly 800 criminal cases at Standing Rock, and nearly all but a handful of these cases resulted in dismissal. So really getting into what is lawfare and how is this a threat to judicial impartiality and due process. When we generally discuss lawfare, we're talking about the weaponization of the law as a tool to achieve a strategic or political goal, and it implies an action that is often not brought in good faith, right? And a few contexts where this is commonly used, some have been narrated already by Neri and by Salahuddin, include political lawfare, right? Using legal proceedings like lawsuits, investigations, criminal charges to damage or discredit political opponents. We have international lawfare when states or organizations are using international law as a means to challenge the actions of other nations, often to constrain military actions or affect public opinion. And you have strategic lawfare when primarily non-state actors or corporate actors use litigation against less resourced opponents to silence or intimidate targets. In a historical context, lawfare is not new, but its scale, visibility, and implications are growing. So if we take a quick look back, in the United States, we saw the rise of COINTELPRO from 1956 to 1971, which was an FBI program targeting civil rights leaders and activists through surveillance, infiltration, and legal harassment. We also see this in the roots of the colonial legal system, right? Laws used to legitimize occupation, dispossession, and suppression of resistance in colonized territories. Specifically, the doctrine of discovery in the United States still has a foothold, which essentially gets rid of Aboriginal title and dispossession. It's the forced dispossession of Indigenous peoples and Indigenous lands. In apartheid South Africa, there was a legal codification of racial segregation and repression, and dissent was criminalized. It's something that we've continued to see. Last slide, Erin. And then in modern implications, we are seeing the erosion of civil liberties with the expansive laws and emergency powers that the Trump administration in its second iteration is extending far beyond the use of their intended scope of executive orders. There is a rise in the chilling effect on activism, right, with the fear of legal retaliation, which can suppress protest, speech, and organizing. And selective enforcement, legal tools that are often applied unequally, targeting marginalized or politically inconvenient groups. And as our previous speakers mentioned, globalization of lawfare, right? Increasing use of international law and also domestic legal systems and legal action as part of those conflicts. So next slide. Specifically within the US, we see targeting of frontline defenders, criminalization of dissent, strategic lawsuits against public participation, eco-terrorism language and enhanced sentencing, surveillance, COINTELPRO, private military and security companies. So I'll go briefly over each one of these. When we talk about lawfare, next slide, targets frontline defenders, human rights defenders are among the first to be targeted for their activism and work in areas of Indigenous rights and environmental justice. So worldwide, Indigenous peoples make up 5% of world population and protect 80% of the world's remaining biodiversity. But Indigenous peoples are on the front line struggles for existence and the earth. In the Frontline Defenders Global Analysis 2022 report, there were 401 human rights defenders killed in 26 countries. The vast majority of these were working on issues related to the environment or Indigenous peoples. The United States is not covered in these statistics, and there is an evidence gap, a critical research gap in terms of data, and this is a need that we have to fill. Indigenous defenders suffered nearly 20% of attacks between 2015 and 2022, according to recent UN and Indigenous Peoples' Rights International report, a report on criminalization. Next slide. So in terms of some of the front lines that we've seen in the United States with the rise of criminalization of protest, there has been defenders charged under broad or very vague laws. There have been critical infrastructure bills passed in over 40 states, especially since Standing Rock onwards. But what we are seeing is this rise in criminalization. So Standing Rock, we had 854 arrests at Line 3, which was opposing a pipeline in northern Minnesota. There were over 900 arrests at Mauna Kea in Hawaii on the Big Island. There were over 30 kupuna or elders that were arrested to try to prevent desecration of their sacred mountain. And Black Lives Matter saw 14,000 arrests in 49 cities. At Standing Rock, we've mentioned this, but 800 arrests of water protectors, the majority of which were dismissed, which also talks about, is something brought, right? Is prosecution brought in good faith, or is it brought in bad faith? And this is an example when you're seeing the majority of cases being dismissed. There's likely a likelihood that these cases were not brought in good faith in the first instance or not on solid legal ground. Excessive use of force is something that we saw also at Standing Rock, and the results out of that were the critical infrastructure laws passed, sharing information between law enforcement bodies across the United States and private military security companies, SLAPP suits, which we'll cover today, the Energy Transfer versus Greenpeace case, and enhanced sentencing. So importantly, as Nettie was mentioning, red tagging. In the US, maybe since the McCarthy era, and now we're seeing this, additional rollback in terms of the Trump administration and an attack on the rule of law and due process, but we're seeing language really weaponized, and it is part of that weaponization strategies of lawfare, right? And language as a weapon historically in the United States has been used, and we've seen in recent years the rise of the term eco-terrorism. And just yesterday was Earth Day here not just here in the United States, but everywhere in the world, was Earth Day. But one of the things that organizations here in the US were preparing for was a potential executive order that could have targeted environmental organizations. And there has been a general attack or a broader attack on the nonprofit sector, particularly for organizations working in these areas of environment, climate, indigenous rights, and a concern that targeting, right, or this similar to the red tagging as eco-terrorists or as threats to the interests of the administration could prevent continued funding, continued operations. So in the 1970s in particular, we saw the rise of eco-terrorism as a term. And there have been congressional hearings on this idea of eco-terrorism. And I have some excerpts here, but you'll see that the congressional record says that eco-terrorists were, quote, just as dangerous and deadly as drug producers, right? And mentions Earth First activists as part of a, quote, terrorist encampment, and describes their tactics in very derogatory terms. Congress, following the hearing, criminalized the use of hazardous or injurious devices on federal land with the intent to obstruct harvesting of timber in 1988. And then a decade later, we saw this again in 1998. There was a new House Judiciary Committee subcommittee on crime held a new hearing on ecoterrorism. And during that hearing, Ron Arnold, who is largely considered the father of coining the phrase ecoterrorism and was an industry person, defined ecoterrorism for the committee as a crime committed to save nature, including, quote, every crime from trespass to murder. So for those of you that are in the audience and are lawyers or even the non-lawyers, you can understand that this is an entire body of law, right? Criminal law covers all of the crimes from trespass to murder. And so a single crime cannot actually be encompass that whole thing, right? And then we see 10 years later again, or just a few years later, actually not 10 years, 2002, House Resources Committee held a new hearing on ecoterrorism and lawlessness on the national forests. And there, next slide, the chief of the FBI described the rise of extremist groups by disaffected environmentalists since 1977. And he acknowledged and narrated, he acknowledged that the vast majority of defenders are not violent. However, sometimes volatile talk, quote, transgressed into unlawful action resulting in property damage. So we see this rise, right, in the early 2000s of ecoterrorism and extremism as equated with destruction of property. The FBI further defined ecoterrorism as the use or threatened use of violence against innocent victims or property, again, by an environmentally oriented subnational group for environmental political reasons. And when we talk about the effects, next slide, of what this language can do, I mean, the effects are dire. In the case of Jessica Reznicek, pictured here, in June 2021, she was sentenced to 8 years or 96 months in federal prison after pleading guilty to acts of property damage. She caused to the Dakota Access Pipeline as a water protector there, which was not operational at the time. It did not pose a threat to human life, but the property damage amounted to, a substantial amount. The federal district court in her case was sent a letter in 2017 by 84 members of Congress, written to the former Attorney General Jeff Sessions, requesting that Reznicek and other protesters who tamper with private property like pipelines should be prosecuted as domestic terrorists. And the authors of this letter, importantly, received a combined $36 million in campaign contributions from the oil and gas industry. Accordingly, the federal district court applied a terrorism sentencing enhancement that increased her sentencing range from 37 to 46 months after pleading guilty to 210 to 240 months. And ultimately what she was sentenced to was 8 years. So she's serving that time But we see that sort of enhanced sentencing and applying the ecoterrorism language, right, which was industry coined and on the rise since the 1970s, and part of the Green Scare, part of the red tagging, part of what we're seeing today in the Trump administration's labeling of judges as judicial activists, lefty judges, et cetera. This kind of language is important when we're talking about what is happening right now in the rule of law and due process. Next slide. Salahuddin mentioned doxing, surveillance. That's a form of surveillance as well, but we saw surveillance in COINTELPRO. It's part of that COINTELPRO legacy, right? The use of COINTELPRO or counterintelligence operations in the 1960s was vastly used against liberation movements like the Black Panthers, the Brown Berets, and the American Indian movement, which were all seen as dissidents, right? And present-day counterinsurgency tactics have included heightened surveillance, violations of the rights of privacy and association. We're seeing reports of lawyers being targeted upon re-entry into the United States with questions about where their phones are, where their phones have been, what they've been doing, who their contact lists are. I mean, these are all strict violations of the rights to privacy and association. And one of the things that we are also very concerned about right now in the United States is this targeting of US citizens, residents, and anybody in the US based on race, political ideas, and political affiliations. I think this is highly seen in the case of individuals that have been arrested under this current administration for their political views. Next slide. Private military and security companies, also part of the lawfare tactics, right? PMSCs are private contractors engaging in conduct amounting to cruel, inhuman, or degrading treatment, or not. They're non-state actors, so there is limited or no accountability or oversight for human rights violations that they commit. At Standing Rock between September 2016 and February 2017, Energy Transfer, the company behind the Dakota Access Pipeline, hired at least 76 county, state law enforcement, and mobilized National Guard and private security firms, including Tiger Swan, which was a former U.S. Department of Defense contractor with offices in Afghanistan, India, Iraq, Japan, Jordan, Latin America, Saudi Arabia, and the U.S. But importantly, they were trained in counterterrorism operations, right? And the Intercept has done a really great job at reporting on this. At the time, Aline Brown was one of the main reporters on this, but she covered truthfully how within their leaked WhatsApp messages, contractors from Tiger Swan used terms and euphemisms for, used terms like jihadists when referring to water protectors. So in international documents at the UN, there have been reports on the use of private military and security companies, and they have been termed a euphemism for mercenaries. Next slide. So getting to strategic lawsuits against public participation, which is one of these tactics of what is lawfare and one of the most significant attacks on judicial impartiality and due process. Strategic lawsuits against public participation are filed mainly to use the legal process itself to impose burdens on an adversary, right? Intimidation, silencing. And in this case, the Energy Transfer versus Greenpeace case, this was certainly an example of that. Those who supported the No Dabble protest, or the protests against the Dakota Access Pipeline in North Dakota, Standing Rock. SLAPs are generally filed by a corporation, but have in some countries been filed by government bodies against civil society organizations, groups, individuals, or directly impacted communities in retaliation for speaking out on issues of public importance. And some of the factors that are considered in weighing whether a lawsuit should be considered a strategic lawsuit against public participation include the nature of the activity that's being targeted, the power imbalance between the parties in terms of resources, disproportionate claims of damages, the abuse of procedural aspects of litigation to try to punish the defendant, and attempts to use the legal action to create a broader chilling effect on free speech. So as you'll see in the Energy Transfer versus Greenpeace case, these are all met here. So to give a little bit of context, we have of why this is important and how the Energy Transfer versus Greenpeace came about. People flocked to Standing Rock because there was a threat to the Missouri watershed. There were 12 million people that live in the Missouri watershed. It's a municipal water supply for over 3 million, and there's 891 intakes for federal, private, and tribal irrigation. Lake Oahe, importantly, is the primary source of water for Standing Rock and Cheyenne River. Next slide. With the energy transfer, next slide. Energy Transfer's safety record and has been poor. The pipeline continues operating illegally with no proper permitting since 2020. Energy Transfer's poor safety record led to debarment by the EPA, which up until just recently meant they could not enter into federal contracts. And federal debarment specifically occurs as a result of criminal or other improper conduct showing serious poor performance and questioning honesty, ethics, or competence. And in the case of Energy Transfer, Energy Transfer has pled guilty to 48 criminal convictions on environmental crimes, where they concealed drilling fluid leaks that resulted in water contamination at 21 sites in Pennsylvania in 2017 and in Ohio in 2017. So this is the background behind the case study of Energy Transfer versus Greenpeace. So the parties, and you can go next slide, sorry. In 2017, SLAP suit was filed by the Energy Transfer Company against Greenpeace in a federal case. This case was dismissed in 2019 because the court saw what it was. It was a SLAP suit and it was dismissed as meritless. And then in 2019, Energy Transfer refiled the case in the state of North Dakota. One of the things they allege, or several of their allegations, are defamation and conspiracy using a racketeering law. They say that Dakota Access Pipeline didn't threaten water, that there was no unjustified violence, no desecration of cultural or sacred sites. And finally, just this past month month and a half, trial in February through March resulted in a $669 million jury verdict in North Dakota, in Morton County, the exact same place where water protectors were tried in their cases from Standing Rock. And I'll skip this slide. So why judicial impartiality and due process matter? And in the case of Energy Transfer, actually, maybe we go back to that slide real quick. Previous slide, yes. The claims against Greenpeace were vastly that Greenpeace was responsible somehow single-handedly for all of the damages that Energy Transfer received during the Dakota Access Pipeline protests. They essentially said during this case that Greenpeace had funded protesters, which gives credence to a popular far-right conservative talking point in the United States currently. But there were other forms of defamation here that they alleged, specifically saying that it was untrue that the Dakota Access Pipeline traverses Standing Rock Sioux Tribe lands, which the tribe itself has disputed, and it does cross unceded treaty lands. They also disputed in this case, Energy Transfer used excessive force against peaceful protesters. So although the sheer violence that was present at Standing Rock is on full display for the world to see, it's a Google away. This is something that they also brought up against Greenpeace, right? So we're talking about good faith or bad faith arguments. This is an additional one. And then they also said it was false that Energy Transfer deliberately desecrated Native American cultural resources, when tribal experts have said the exact opposite. In this case, right now, where we're at is that the judge has received motions by Greenpeace to limit the jury the jury award and cut down the jury award. During the trial itself, one of the problems that we saw was a lack of judicial impartiality and the acceptance of jurors that were tainted by the oil and gas industry. So it was found that 6 out of 11 jurors had direct ties to the oil and gas industry in a state where the oil and gas industry are the primary source of sustenance. So the question arises, can there be due process, or could there have been due process truthfully for Greenpeace in this specific geographic area? Next slide. In Morton County, they found that there was 97% of the jurors surveyed pre-trial found that they could not be, or said they could not be, impartial. So why does this matter, right? Judicial impartiality ensures that judges can be neutral, that they're independent. And as Neri and Salahuddin have mentioned here, it protects against political influence. It builds public trust in the rule of law. And due process guarantees are enshrined in international law generally, and in the United States, in the US Constitution, in the 5th and 14th Amendments. This includes the right to a fair trial, legal counsel, the right to be heard. It guarantees fair treatment under the law and shields individuals from arbitrary detention and abuse. So without these safeguards, and what we're seeing during this current Trump administration, the law is becoming a tool of repression, right? And justice is becoming selective and not equal. So without these safeguards in place, lawfare can really thrive. Next slide. I won't go over these extensively as they've been covered already, but again, sources of international law and judicial impartiality and due process include the Universal Declaration of Human Rights, which again states that it is everyone is entitled in full equality to fair and public hearing. The International Covenant on Civil and Political Rights, the ICCPR, that says everyone shall be entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law. But importantly here, both instruments are binding on the United States. So we have in the US Constitution, the Supremacy Clause enshrined in Article 6, Clause 2, which states that treaties are the supreme law of the land. So both instruments here have been ratified, are binding on the US, and they affirm judicial independence as a universal right and not a privilege. Next slide. And some additional guidance on judicial integrity. The Human Rights Committee, which is the monitors the signatories' compliance with the ICCPR, has stated that the right to be tried by an independent and impartial tribunal is an absolute right that may suffer no exception. This is from one of the cases that Neri cited. Judicial independence is thus both institutional, but it's also personal. And importantly, judges must not decide cases based on personal preferences. In the energy transfer case, there were many times I served as one of the monitors on the case, and there were many times when the judge seemed to not know what to do with, objections, and would sort of decide on a whim, or he'd look up at the ceiling to see if there was, some sort of divine intervention for him to know what to say next. In the UN Basic Principles on the Independence of the Judiciary from 1985, it also states and requires the judiciary to ensure that judicial proceedings are conducted fairly. And the Bangalore Principles of Judicial Conduct from 2001 uphold these 6 values of independence, impartiality, integrity, propriety, equality, competence, and diligence. So this reinforces ethical duties that protect the rule of law. And together, all of these instruments that we've talked about today affirm that fairness, impartiality, and due process are non-negotiable in a just legal system. Next slide. So what we're seeing is that the rule of law is fragile. It can be undermined when power is exercised without accountability or respect for legal institutions. Right? We've seen this in the Energy Transfer versus Greenpeace case, where this lawsuit could not only threaten the survival of Greenpeace as an organization, but also have a broader chilling effect on advocacy, especially for environmental and indigenous rights groups, and signals a broader legal weaponization against nonprofits, as well as the erosion of judicial authority, which Salahuddin spoke about extensively with Trump 2.0 administration actions of publicly attacking judges who have ruled against executive orders, like the DC Circuit Judge Boasberg, who ordered the return of Venezuelans that had been deported without due process, calls for impeachment of judges perceived as obstructive, which has prompted a response from the Supreme Court of the United States saying, the proper process is to appeal, and defying court rulings, which includes the deportation of 200 Venezuelans to a maximum security prison in El Salvador. And finally, threats to the nonprofit sector, which I've discussed, but HR 9495 is currently pending in the Senate, which would give unbridled access to the Treasury Secretary to determine that any nonprofit organization or civil society organization could lose its 501c3 status if it is labeled a threat. And I know I'm up against time here, so I will close with the last slide. Just some key takeaways. Lawfare is on the rise. Judicial impartiality and due process are essential, and without independent courts and fair trials, justice becomes political. And these principles are guaranteed under both domestic and international law, so we have to do our best to use both, right? Spark judicial resistance to measures, as Salahuddin mentioned. Global norms set clear standards. So using the norms in the UDHR, the ICCPR, the UN Basic Principles that affirm impartiality and independence are non-negotiable rights is important. And we know that the rule of law is under threat. It's something that we're seeing, that we've seen in other places. And what I will say is that defending legal integrity is a collective responsibility. So it is up to us to collectively ensure that judicial independence, civil society, and legal norms are upheld, and that democracy, equality, and human rights are not just on paper. Thank you.
Thank you, Natalie, for your explanation of lawfare. Really laid it out, different types of lawfare as a threat to judicial impartiality and the weaponization of language, as well as attacks on nonprofits, immigrants, and those who criticize government policy and corporate interests. Thank you so much. Now we will have a brief period of exchange if any of the faculty members, I think we lost Neri, it's in the middle of the night in the Philippines, but if Natalie and Salahuddin want to comment on each other's presentations or even Neri's presentation, or ask each other any questions, and then we will take questions from the audience.
Thanks, Marjorie. I'll just share, Salahuddin, when you were speaking earlier about, how when you attack, or when a government attacks a judge or lawyers, right? What we are seeing is an undermining of the entire judicial system. And earlier today, I opened my phone to an article that says Trump blasts judge in Perkins Coie executive order just before oral argument. In a post, Trump called U.S. District Court Beryl Howell a highly biased and unfair disaster, claiming she has a bad case of, quote, Trump derangement syndrome and was, quote, an unmitigated train wreck. So, I'm curious because I know that right now, as the world witnesses this collective meltdown of the rule of law that we are experiencing in the United States, I'm very curious about your thoughts on how this kind of attack, not just on judges, but also on lawyers, right? The targeting of immigration lawyers, the targeting of lawyers that even large executive, like corporate law firms such as Perkins Coie, which is one of the largest law firms in the United States, how you're seeing this abroad. And I really appreciated also your notes on how we need to resist and spark judicial resistance to measures. And then it's important that we push back. So thank you for that.
Thank you for your presentation. I was just, these kind of attacks that, we were seeing with the Trump administration. I mean, we have similar kinds of things happening here in Pakistan, where judges who, take past decisions that the government doesn't like, you have, it starts with some politician or member of the cabinet, saying something about the judge, that, he's politically biased, or he should take off his robes and come and do politics. And, then it will, what happens after that is that there'll be like a social, in Pakistan, there'll be a social media campaign against that judge. He gets mercilessly trolled day and night on social media, and then the news channels pick up on it. And I think the attempt is not so much necessarily to just intimidate that judge, but create a kind of atmosphere where all judges are, at the end of the day, then they start thinking, do we really want to, you know, expose ourselves, our families, etc., to these incessant attacks? And it creates this chilling effect for judges themselves. It happens with the lawyers too here. You have the same kind of social media, trolling. And then, in Pakistan, we've also had directly cases where lawyers will be, abducted or arrested, So that happens a lot here too. The other thing that, I was struck by your, presentation was about the use of lawfare. And, it seems to be more advanced and well planned in the United States. But we have something like that, especially in relation to speech. So you'll have, when you have journalists, etc., who report on certain things that the government doesn't like, they're hit with, defamation cases left, right, and center. And Pakistan has recently passed a Prevention of Electronic Crimes Act, which was essentially originally intended to target, cyber terrorism. But they've also put in like defamation clauses in that anyone who, willfully attacks a government organization or, defames it. So then what will happen is that you'll have all these complaints coming in from government officials, and there'll be, a flurry of those complaints in different jurisdictions. So basically, then journalists then decide they just can't afford to face that, and they stop reporting those things. So it was very interesting to see the parallels.
Natalie, I had a question for you. Did the judge in the Greenpeace case have any ties to the oil and gas industry?
Not directly, Marjorie, but there were some concerns that in that particular state, it's an oil and gas state generally. So it's the bread and butter, right, of what everybody lives off of. And so the likelihood, not just for a judge, but also for the jury to, skirt that structural dependence, was very difficult. And it's something that pretrial jury surveys showed that it would be highly impossible, virtually impossible. So you had judges recuse themselves. All of the judges in that judicial district recused themselves. And this judge was appointed from another district, from a different area, to come in and serve as a judge. But one of the things, and it's hard to say this when we're seeing the attack on judges, so I don't mean to attack him, but the reality is that one of the key canons of judicial conduct is competence and diligence. And that's something that was on full display. And he many times during the trial said, I've never done a complex civil litigation case. You lawyers that are trying this case from Energy Transfer and Greenpeace have much more experience than I, small town judge, do. And couched it in those terms. And that's also concerning and impacts questions of judicial ability and due process, right, in that case in particular. And just to respond to what Salahuddin was mentioning too, I think what I've been finding strengthen these past few days and weeks, and it's been less than 100 days, but it just feels like an eternity right now. But what I've been finding strengthen is examples of historical examples and contemporary examples of things and in other countries, right? Like what you've expressed, what Neri was citing, of countries that have experienced this regularly, right? Where this is not the exception, this is the rule. And it has happened over and over and over again. And so we're seeing these, same stories in a different place. So thinking about how do we create that resilience and how do we create strength and respond in this moment of great threat. And the reflection I've been coming to is that human rights have never been freely given, right? And human dignity has never been freely given, that it has always been demanded and it has always been defended. And so sometimes I think we like to think of maybe a golden age of human rights, but there has been no true golden age of human rights, right? When we think of the UN, where I am at today, it's a recent construct, but we have systems and we have community solidarity and institutions in other forms of governance systems that have existed for many, many, many years, centuries, millennia. So it's not abstract. I think to the idea of defending human rights is not abstract. I think we have to ground ourselves in community and ground ourselves in strategy. I think it's in a moment for creativity, and it's a moment for joint struggle.
Thank you for that, Natalie. Just to put together a couple of the questions in the few remaining minutes, there was a suggestion that to combat internal biases among the judiciary, gender and class biases, perhaps gender and social background should be considered when appointing judges to make them more independent, possibly through quotas. And then what can we do to combat lawfare and the outsized influence of corporate interests in the judicial process? That's to either or both of you.
Yeah, go ahead, Salahudin.
Why don't you start?
I think in the US it's hard to right now, especially with the rollback on diversity, equity, and inclusion measures. I mean, that would be something hard. I think generally to include an additional space for women or based on gender. It's hard to say, and I don't have a strict view on whether quotas would actually be helpful. I think that there have been measures in the past within the US, not specifically within judicial and like for judicial integrity purposes, that have had varied measures of success. So I'm not sure that a quota would necessarily fix it. It's hard to say what would be a good fix. I think part of it is education. I think part of it is like a study of history and figuring out how do we prevent further rollbacks on not just the guardrails for corporations, but also thinking about the guardrails for education. I didn't think I'd be speaking from a country that's burning books and that is banning books, right? And we're seeing that as well. So there's also censorship in terms of the kind of information that can be accessed by the public and by citizens, the citizenry and people living in this country. So I think that's of huge concern as well. And I tend to take a historical arc and a historical look at this, right? Because it is in context. And I think it's important to see that context.
I just wanted to add, I think I agree with Natalie that quotas for the judiciary are perhaps not a most effective way of dealing with this problem, and that continuing education has to be the answer. I find, at least in Pakistan, one of the big problems is that judges tend to belong to a particular social class, and they have relatively little exposure to different ideas. And I think that there needs to be a greater process of, I mean, what will happen is that you'll have a judge, he'll happily go to his private club where he will listen to the views of, um, top professionals. He'll listen to the views of, big businessmen and, their ideas about the economy, their ideas about what, the justice should look like. And but you'll never have judges who are just interacting with trade unionists, for example, and that tends to then color their way of thinking in a particular way. So there needs to be an exercise to how to sensitize and educate judges better whilst they're doing their job.
Natalie, can the Greenpeace case be appealed to the U.S. Supreme Court?
It can. I know that they are planning, they've announced that they are planning an appeal. And when I say they, it's 3 different Greenpeace entities that were brought into the suit. Was Greenpeace USA, Greenpeace Fund, which is a separate entity, and Greenpeace International, which is based out of the Netherlands. In the Netherlands, Greenpeace International has also brought based on an anti-SLAPP statute in the European Union, has brought a case against Energy Transfer. So it's far from over. It's still going. It's the gift that keeps on giving, I suppose, or the case that keeps on giving. So we will see where the next legal battle in that saga continues. But just to close, some closing thoughts too, Marjorie, on what Salahuddin just said. I think the education is one tool, the law is one tool. I know that we're speaking here today amongst many of us are lawyers, but I think sometimes we have as lawyers the sense of, well, we have to go through the courts, right? And the courts are the only answer. I think that what Salahuddin said earlier about the importance of sparking judicial resistance is critical. We can't just roll over. We have to find a way to have strategic, the same way they have strategic lawsuits against public participation, we need strategic lawsuits for public participation, right? Something that is the counter to that. But I would also caution against seeing law as the end all, and really looking at the importance of community strength and solidarity, the importance of finding ways to be courageous during this time, because silence doesn't mean protection, but also being smart about it. So it's a delicate balance. Thank you so much.
Thank you, Natalie. Thank you to our faculty, Neri, Salahuddin, and Natalie. Thank you to our interpreters. Thank you to our administrator, Aaron Sakakini, and to all of you who attended to make this seminar a success. Our next program of the People's Academy of International Law will take place on Monday, May 19th at 9:00 a.m. Pacific. That's 12:00 p.m. Eastern. It will be Course 7, International Law of Armed Conflict and Challenges to its Enforcement. The faculty for that course will include Chantal Maloney, Ali Rais Tusi, among others. So thank you again. See you all there.